Hello, this is Matt on the Moon Lambeau channel, and I've got a quick legal update for you. You know I've been following the SEC versus library case. I don't happen to own any library credit tokens, but that doesn't matter. I don't like the SEC attacking every participant in the damn crypto space. And this matters for XRP holders in particular, because the SEC versus library case is going to come to a full and complete conclusion before the SEC versus Ripple case. There will be an impact. This does matter to us, and so I'm going to continue to pay attention to this, and so is attorney John Deaton. And in fact, he had something to say about the approach that the SEC is taking, and he said that it's, quote, reckless, overbroad, and far-reaching, and I'll share with you exactly why he said that. So plenty to share with you in this latest Moon Lambeau Hot Jam. But before going further, I do want to be clear that I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Well, I'll tell you what, you'll be very pleased to know, not actually, that the SEC is engaging in the same nonsense, buffoonery, and hoo-ha that they are engaging in regarding the Ripple case as well. They're trying to skirt the system, completely disregarding local court rules. They don't care. These are arrogant people that think that they're lords of the land, basically. There's no one above them. My gosh, these people are complete and utter asshats. A shout out to XRP community member and attorney James Filan, who shared this most recent legal update, and he wrote the following. In the SEC versus library case, library has objected to the SEC's motion to exceed the summary judgment page limit and has moved to strike the SEC's statement of undisputed facts. So here's the long and short of it, my friends. The SEC, they were confronted with a limit, as was library, when it comes to these summary judgment filings. So that's the leading up to the end of the court case summary judgment where the final conclusion is. Each side could submit a max of 25 pages. Them's the rules. And the SEC's like, we're not going to do that. And so they threw an extra 30 pages on top of that. 55 pages. I kid you not. And they didn't ask for permission. They just did it. They're like, oh, oops, I don't know. Now I can't do that. They just did it. Oh, yeah, my ass, you didn't know. Come on. These people aren't stupid. They're just bad people. They're very, very bad people. And so take a look at this. There's only a couple parts of this whole document that I want to read. This document's 5 pages, but I know the parts I want to go to, beginning with the opening here. And so this is from Library's legal team. It reads as follows. Defendant Library moves to strike Plaintiff Securities and Exchange Commission's 30-page statement of undisputed facts, which the commission filed in addition to its 25-page memorandum of law in support of its motion for summary judgment. In violation of the local rules, the commission filed a total of 55 pages in support of its motion for summary judgment without seeking leave of court to do so in advance. So, folks, they did this. They're acting like it was just some sort of honest mistake, but they're requesting that this stand. And Library, their legal team, had a strong response, and they're having none of it, my friends. Take a look at this. The commission's failure to follow the local rules leaves Library in a precarious situation. If, on the one hand, Library does not respond to the commission's 30-page statement of undisputed facts, Library risks those facts being deemed admitted. And then they wrote in parentheses here, all properly supported material facts set forth in the moving party's factual statement may be deemed admitted unless properly opposed by the adverse party, in parentheses. And so they're in a pickle. They're like, well, okay, what do we do? If we respond to them, then there's, I'm going to read the rest of there's the rest of this paragraph anyway, so you'll see what the problem is. But if they don't respond to it, I mean, the point's already made pretty clear there. Is that an admission that what the SEC stated is correct? Because they weren't even supposed to be able to have all that additional information presented in the first place in this summary judgment filing. Anyway, so the Library's legal team continues. If, on the other hand, the Library does respond to the Commission's 30-page statement of undisputed facts, either in its allotted 25-page opposition brief or in a separate filing, should this court allow, library continues to be harmed for at least two reasons. First, library would be required to spend additional time and resources responding to the Commission's 55-page summary judgment filing, more than double the length allowed under the local rules. And second, even if time and money were of no concern to library, which it is, it still would be inequitable to let the Commission's 55-page filing stand when library was allotted only 25 pages for its affirmative motion. If library had been allowed 30 extra pages for its own summary judgment motion from the outset, library likely would have made different strategic decisions concerning how to approach its filing, including by adding certain facts and or legal arguments. So folks, doesn't this sound a lot like the crap that Ripple's been putting up with? I wish I could, there's one example in particular, and it just popped in my head, but I can't remember exactly what it was. But the SEC in the Ripple case, they broke the court's local rules, and the judge ended up, I think it was Judge Knepper, I'm pretty sure it was Judge Knepper. She came down verbally harsh on them, but then allowed them to get away with whatever they were trying to get away with. I wish I could remember specifically what it was, but whatever that is, it entered my little Moon Lambo brain when I was reading this. I was like, yep, these people are just the freaking worst. Grinds my gears, folks. Attorney Fred Rispoli, who is a member of the XRP community, responded to Attorney Filan and wrote the following. Good news is from library judge ruling so far is that he fits the old school, follow the rules with no exception model. While I don't think he'll come down with max force on SEC on this mess up, I do think, in his eyes, that the SEC took significant credibility hit with such a basic error. Yeah, so there you go. So I hope that ends up being the case here, and that the judge is going to be no nonsense and not allow this and credibility. Man, does the SEC have any credibility to start at this point? The answer is no. That was an easy one, right? Then there was another XRP community member who is an attorney. His name is Bill, and he said the following on this. Thanks, James. Obviously, the SEC's regulation by enforcement optionality extends to court rule optionality, right? The SEC again shows it will not follow court rules to obtain a tactical advantage and then have the court grant it an indulgence and allow it to pass. Strong library response. Yeah, I think library had an excellent response, and I just shared a couple snippets, but yeah, it got to the point, and I don't see how anybody could be so bad at logic that they don't see what's actually going on here. So we'll see. But more egregious than that is the following, and this is what ultimately Attorney Deaton ended up commenting on, and this is just absurd to me. Let me make this full screen here. They got a little screen grab from a SEC file in here against. Yeah, can't believe this. Here's what I'm going to do. It's all on your screen right now, but I'm going to read what there's two tweets. I'm going to read the first tweet from library, and then I'm going to read what's on the screen, which is what the SEC filed against library. So here's what library had to say on Twitter. It's hard to overstate how broad and devastating this claim from SEC is. If purchasing for usage is insufficient to make something not a security, then practically everything is a security. Not just every cryptocurrency, but Beanie Babies, baseball cards, houses, etc. So why is library stating that? Well, here's the snippet from the SEC. This is what they're actually asserting in court. Think about how much is on the line here. Every cryptocurrency on the planet is a security if library credit is, if XRP is, if one of them is, then all of them are. That's so much at stake here. That's why I'm telling you, like, I'm not saying that if this goes badly for library that it's going to completely devastate the Ripple case. I'm not saying there's binding precedent that will be set, but it could be bad. It wouldn't be good. I mean, it's just another bit of ammo that the SEC would have. But here's what the SEC wrote. The possibility of using LBC, that's the cryptocurrency of library, LBC, on the library network for video-related purposes, which purchasers could do during most of the offering, but not at the beginning when library promised LBC to testers, does not negate the expectation of profits by a reasonable LBC purchaser. So that's why they're saying, even if there's utility, this is what they're saying, even the SEC's arguing, even if there's utility, that it doesn't negate the fact that there's an expectation of profits by an LBC purchaser. So think about that. Anything that you purchase, even to use it, if the primary purpose is for usage, is a security. Like, what? Think about this. That's why they said, okay, Beanie Baby, this is what Library said. Everything's a security then. Not just cryptocurrency, but under this way of thinking, Beanie Babies would be securities. Because you buy it to use it maybe. Maybe you cuddle with it when you go to sleep, right? Maybe you're hoping for the price to go up too, right? Baseball cards. What about your own home? You're using it, but you're expecting the price to go up, right? So what's not a security? That's the problem. And then in the second tweet, Library wrote, how is this not still true of Ethereum even today? See, think about it. So look at what they're arguing here. And look, nothing against Ethereum. It's a critique of the unequal distribution of justice, let's say, in the world of crypto, because the SEC is going after not Ethereum, going after Ripple, going after Library. They've picked the ones they want to go after here. But how is this not true of Ethereum? Because think about it. People, even if there's utility for Ethereum, let's just grant that there is. Let's just say that for this conversation. People are still buying it because they expect that it's going to be worth more in the future. So if there's a single element of speculation, hope that something's going to be worth more in the future, then it's suddenly magically a security? Folks, we got problems if that's true. These SEC asshats can't get away with this, right? And so Attorney John Deaton retweeted that, and he wrote the following. To everyone in the crypto market, do you see how reckless, overbroad, and far-reaching the SEC's argument is? It is arguing the same nonsense in the Ripple #XRP case. The SEC is being both intellectually dishonest and lazy. The SEC's burden should be to prove a specific sale or transfer of LBC at a specific time constituted a transfer of an unregistered security. Instead, it argues all LBC tokens are securities despite the fact that many people acquired LBC for a non-investment use of the token. That's what Attorney Deaton had to say, and he obviously, as per usual, he's hitting the nail on the head. Now, also, I reported in a previous video, you may have heard this, that Library is arguing that over half of the people that hold LBC are using it for utility purposes. Over half. So how dare they come in and make this claim? Assuming that data is true, I have no reason to believe it wouldn't be true. That'd be wacky for Library to be lying about that, so I believe it's true. I believe them. But my gosh, how dare the SEC come in and make this bogus argument? Even if there's utility, if anybody's expecting a price to increase, it's still a security. You get the hell out of here with that nonsense. Oh my God, the SEC, what a terrible organization. These people are the absolute worst. So we'll keep watching this. I mean, again, this case is going to be ending relatively soon, and we'll find out. Hopefully, it's a win for the Library team. My gosh, because look, if it is, maybe that's more ammo for Ripple. But if it doesn't go well, it's just another thing. And I don't know that it would necessarily change the outcome of the Ripple case, but that's the thing. I don't know. Like, I literally don't know how powerful this would be. And again, like I said, I don't, from what I understand, there's no reason to believe that it would be binding on the court, but still it would have an impact because it's still a precedent-setting type of thing. We'll keep watching it. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write, so that would be a very, very, very bad idea. Until next time, to the moon, Lambo.